Good morning, ma'am. Are you Glenda Williford?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Give me just a second to get that. Sorry, it's taking a minute for my computer to get pulled up here.
This morning, Your Honor.
Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges
Judge, we've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's
At this point, the legal outcome is still flexible. The judge has the authority to revoke probation immediately, but chooses not to. That decision signals conditional trust. In courtroom dynamics, this is a narrow window where compliance matters more than explanation, and demeanor can matter as much as the violations themselves.
plenty of time after that she has still on probation. State tenors number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
Okay.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
This is where courtroom tone shifts. The judge's concern moves from procedural to personal control, not sympathy, but command. Emotional reactions can humanize a defendant, but they can also raise red flags about impulse, judgment, and respect for the court's authority. From here on, every word carries weight.
I had a statement prepared for explaining the only reason I was doing marijuana. I was because of my image. And I will promise you, on Jesus' happy golden soul, that I'll never touch the shit again. Let me go home.
Are you seriously going to stand here and talk
No.
like that?
No, ma'am. I didn't mean to. I'm terrified. I'm sorry, ma'am. I just didn't realize how much trouble I would get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I really was trying to.
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff.
Went better than I thought.
Really?
This is one of the times it's great to have on camera.
Oh.
Never see me. I'm literally biting out.
You just never know.
Jesus is what?
I mean, you use the F word and Jesus in the same sentence. I feel like that's a problem.
She said frigate.
Well,
You know what she meant.
I know what she meant.
In the end, the court chooses supervision over incarceration, but with clear boundaries. The judge affirms the agreement, extends probation, and makes the consequences unmistakable. This wasn't a dismissal of the violations. It was a calculated pause, a second chance paired with an explicit warning about what comes next if the court's conditions aren't taken seriously.